Any date you
Madam, what is the case?
Sir, it's about my termination,
You are working in which department?
judiciary, as a
Okay.
judge.
Acha.
Lordship will come to the last order which was passed. Lordship's query was very specific. What is the difference between Ji?
This matter we have heard sometime.
Ji.
Oh yes. Madam,
Yeah. Sir, regarding your query, which you said last time is to clarify the difference between dismissal and termination. And by this honorable court, recently a judgment is passed on 12th June 2023 in matter of Krishna Kumar Kosaria versus State of Chhattisgarh in para number 20, 21 and 22. In 22, the court relied on the learned Supreme Court's judgment on Motiram Dheka versus General Manager North Eastern Frontier Railway, in which the court found that has expressed that the said words mean nothing more or less than the termination of the service of a person's office, the effect of dismissal or removal of one from his office to discharge him from that office, that is to bring about cessation of service. Thus, the said words comprehend every termination of service of a government servant. Article 311, subclause 2, in an effect, therefore, lays down that before the service of government servant are terminated, he must be given a reasonable opportunity of suing cause against such a termination. And in para 21, the inquiry 22, the scope of the word dismissed and removed employed under Article 311 of the Constitution, India.
Madam, a copy हमको भी तो दीजिए.
Yes. In para 23, my lord, the Supreme Court in the matter of Parsattam Lal Dhingra versus Union of India has held that mere termination of service without more of such an employee would constitute his removal or dismissal from service, attracting Article 311(2) of the Constitution of India.
Madam, you were on probation, na?
Yes, sir.
So please tell us, see, when you are on a probation, all right?
Yes,
then, and he is a confirmed employee. So what are the protection can be granted to a probationer employee? You are a probationer.
Yes, sir.
So what is the protection can be granted to you by the Constitution? Please tell us the.
Sir, it is the safeguard is granted under Article 311, subclause 2.
How?
It says that if any
you are not, see, please try to understand the things when you are on a probation.
Yes, sir.
What is your status? Please explain on this issue first.
Yes, sir.
And what is the law which provides that the probationer has to be protected in what manner?
Yes.
You are taking the judgment that will not help you. Prima facie, I tell you.
Yes, sir.
You are, please go and search some judgment on probationer.
Yes, sir. I have searched.
Yes, please tell us. Now come to that judgment. Yes, directly to this judgment. Yes. What is this?
This is judgment passed by the Honorable Supreme Court in the matter of Registrar General High Court of Gujarat versus Jaisri Chamanlal Buddha Bhatti. In this case,
which paragraph you want me to read out?
Paragraph 28. It says that
Huh?
having gone through the silent judgments on the issue in hand, one thing which emerges very clearly is that if it is a case of deciding the suitability of a probationer and for that limited purpose any inquiry is conducted, the same cannot be faulted as such. However, if during the course of such an inquiry any allegations are made against the person concerned which result into a stigma, he ought to be afforded the minimum protection which is contemplated under Article 311 subclause 2 of the Constitution of India, even though he may be a probationer. The protection is very limited, which to inform the person concerned about the charges against him and to give him a reasonable opportunity of being heard. Having noted the facts as they have emerged on the record, can be preliminary inquiry conducted against the respondent in the present case be said to be an innocent one only to assess her suitability. Is it not apparent that certain aspirations were cast on the character institution like the High Court to afford her the subordinate judge while deciding my confirmation, the standing committee while the standing committee dealing with the confirmation of my service, it took in annexure R21, page number 408 of this paper book, certain matters were taken by the standing committee on its meeting held on 31st January 2017. In that, first thing was that I filed a complaint against then district judge on 25th April 2016. That was dropped in that meeting. And this meeting was held for the regarding the confirmation to decide the confirmation about my job. And the second thing was there were 3 complaints that was taken by the standing committee. That is in annexure R24, page number 414, in which first complaint is comment stated 30th January 2016, submitted by then District Judge Ambikapur regarding complaint dated 30th December 2015 by Anju Gupta, ADPO, against the petitioner. There was one complaint she filed against me. In that, it is humbly submitted by the petitioner before this honorable court that above complaint was filed by the Anju Gupta, ADPO, on 30th December 2015, and the comment on the same was sent by the respected District Judge Ambikapur on 30th January 2016, as mentioned in annexure P21, page number 366 to 369. But no action was taken against the petitioner till 31st January 2017. Till 1 year, there was no action taken against me. But it was taken at the time when my confirmation was about to decide. That time, the standing committee took this complaint before it. And this complaint was filed before the extension of my probation. But when we see the specific order, standing committee in its meeting on 24th January 2017, it's mentioned in the annexure R21, page number 408. That time, standing committee directed the Registrar General to keep ready the entire service record of the petitioner with 9 other judges of her bench in my bench, especially after the extension was granted. This complaint was before the extension was granted to me. This complaint was in December 2015, and my extension was on 18th March 2016. And then second complaint was also taken. That complaint was made by the then District Judge Ambikapur against me on 30th April 2016. It is pertinent to mention that before this 30th April 2016, I myself filed a complaint against then CJ Mr. Varial against about his conduct. But he no action was taken by district judge, and then he complained he filed a complaint against me before the Registrar General. And this was taken at the time of deciding my confirmation before the standing committee. And the third complaint was taken by this standing committee is a complaint 10th May 2016 by one R.S. Sukla, ASI. He complained against me, and that complaint was taken at the time of deciding my probation. And this complaint was also made after I complained against Mr. Varial, and also against when I complained against Mr. Varial and the district judge Ambikapur at that time. I also complained about because he has not taken any action against that CGM. I complained about district judge and CGM before the portfolio judge because no opportunity was given to me. So all these complaints were taken at the time of consideration of my probation. That's why I have to get this protection under Article 311 Clause 2 because the complaint were taken. So therefore this case of Registrar General High Court of Gujarat and Justice Chamanlal Buddha Bhatti is applicable.
Now, subsequently, the Honorable Supreme Court has also taken some other view in 2019 or 18. You have gone through with the judgment of it is arising out of, I think, Rajasthan se hai shayad. You just check up it up.
22.
Yes, I think.
Yeah, it's Abhay Jain versus.
Yes. What he says? What he says?
In this case, the matter was also about this additional. He was
On a probation.
Sorry.
He was on probation.
Yeah, he was also in probation.
Where you copy here, आपके पास?
Yeah.
Madam, don't tell yes, बोलिए.
Sorry, sir.
We are living in Hindustan.
So, sorry.
Doesn't look nice.
Sorry, sir.
क्या बोलता है इसमें?
Sir, in this case, Abhay Jain was appointed as an additional district judge in year of 2013, and he was while dealing with some bail matter, he has given bail, and that was complaint against him. He was in probation for 2 years, before. And one anonymous complaint was filed against him stating that after rejection of the High Court on that particular bail, he granted the bail. And kindly, my lord, kindly see the page number, the last page. In para 71, the Honorable Supreme Court held that to conclude, we are of firm view that in the present case, there was no material to show cause unsatisfactory performance of the appellant in terms of requirement under Rule 45 and 46 of the RJS Rules 2010. Moreover, the
Mr. High Court, you tell us
what
are the rules to record a finding whether the performance of the petitioner is satisfactory or not. Whether any statutory rules have been framed, which says how the performance appraisal has to be made. What is the pendency of the, what are the parameters laid down by the rules made in this? We have to tell us on the next appeal. Yes.
My lord, in this case, moreover, the appellant's discharge was not simpliciter as claimed by the respondent. The non-communication of the ACRs to the appellant has been proved to be arbitrary, and since the respondent choose to hold an inquiry into appellant's alleged misconduct, the termination of his service is by way of punishment because it puts a stigma on his competence and thus affects his future career. In such a case, the appellant would be entitled to the protection of Article 311 subclause 2 of the Constitution. Moreover, the adverse comments on the ACR for the year 2015 would not have been the basis on which the appellant was discharged from service. The appellant was never granted an opportunity to improve, and there was no intimation to him about his performance being unsatisfactory. This case is also relevant to my case because my ACR of 2015 to 16, in which adverse remarks are wrote in about me, that was communicated to me after my termination, 10th April 2017. That was communicated to me.
When communicated to you?
10th April 2017, and that is the ACR of 2015-16. And my lord, regarding rule, there is a rule also, rule of the